Welcome to the Andreev Lawyers Succession Planning seminar. Today, we're going to be discussing a structured story across two generations, namely the Jones family. So sit back and listen in. Now, these situations and characters may not be based on any certain situation, but you might think along the way that some things may apply to you. So, generally, thinking about your succession planning should be seen as an opportunity to sit back and take some time out to think about the bigger picture issues. You need to think about the things that do get overlooked in your day-to-day struggle. Succession planning addresses that feeling that things aren't really under control in your life and in place, and provides a strong platform from where you can confidently engage in your life. But it doesn't take care of itself. You need to stop and go through a simple process to make sure that everything's in order. It starts with the why, not the how or what. And as I've said, it's about taking control and reducing the role of chance in life. So one question for you is, how long has it been since you've taken any positive action to ensure that this happens? To start off, I'll introduce you to the Jones family. Now we've got Jeremy and Liz, some country farmers living a few k's north of Pandana. But we have Michelle, who's Jeremy's former spouse. Jeremy and Michelle had two kids, namely Tom and Jesse. And Jeremy and Liz together have one child named Ben. Tom works on the family farm. Jesse is an accountant who lives in Adelaide. And Ben's studying agricultural science at the University of Adelaide in the Big Smoke. Tom's married to Anna, and they together have one child named Alex, who all live on the family farm. As stated before, Jessie lives in Adelaide, who lives with her husband John, who is a doctor, and they have one child named Nick. And Ben is by himself in Adelaide studying, like I've said. Moving forward, I'm going to talk about Liz and Jeremy's current situation, about what they own, how they own it, how they should protect what they own, and just some things that Liz and Jeremy need to think about in order to pass on their farm to the next generation as they would wish. So if we look at Liz and Jeremy's current assets and liabilities, they own a commercial property in Penshaw. They own some farming land, which includes their homestead, which they live on. They own farming equipment. They together own a restaurant, as Liz is a handy chef, and just to do something different besides being on the farm. They own a townhome on the mainland in Adelaide, a beach shack down in Emu Bay, and their self-managed super fund shares and just some savings. But they also have $1 million worth of debt to the bank. So as parents, you'd have a few objectives. After working all your life and working hard on the farm, you'd want to live a modest but comfortable retirement. You might want to do some traveling around Australia. Maybe Liz and Jeremy want to use their assets to provide some sort of income stream and have some capital security. Of course, they want to look after each other when the first passes on. A clear objective would be to help Tom, who's currently working on the farm, take over the farm. But you need to think about, well, what if he wants it now? What if he needs the asset security? But what about Ben, who might want to get involved in the farm in the future? And along with Ben, Jesse, who might be left out, and they need to consider leaving some assets that aren't farming assets, and preferably of the same amount as Tom might be given. But there are unstated objectives that aren't clear at the forefront of Liz and Jeremy's mind. So they'd want to make sure that the assets that they have are protected from a claim against a child. They want to make sure that the assets that they have and pass on don't go to a new partner of the surviving spouse. They'd want the grandchildren to be educated and understand what succession planning is all about, and understand the work and blood, sweat and tears that have been put into the farming land and operation. And most of all, save tax. So what happens if they don't plan? Well, if Jeremy dies first, Tom and Jesse might miss out. And we'll go into this in a bit more detail later on in the presentation. If Liz repartners, the children might miss out, especially Tom and Jesse. If the assets get passed to the kids and the kids get sued or divorced in the future, they might just completely lose their inheritance. Stamp duty, capital gains tax implications could apply. And superannuation could be subject to tax at 17% or 32% when passed down to a dependent. Tom might even leave the farm if he gets disgruntled or gets into some sort of argument with the family or his siblings. Or even two of the children can gang up on the one if they feel like they haven't been provided adequately. So as a brief summary, we'll look at who can make a claim to Jeremy's estate. Jeremy's spouse, Jeremy's children, Jeremy's grandchildren, his former spouse, if some sort of financial arrangement wasn't entered into properly, or a dependent such as Anna, who's living on the farm and is relying on the income of the farm to survive and look after her children. Now I'll pass this on to the principal of Andreev Lawyers, Andrew Andreev, who's going to discuss the process and objectives that the family might need to think about and how to implement that plan.
Thanks, Dimitri. So when we look at a succession plan for a family, we like to follow a pretty clear and relatively simple, straightforward process. So the first part of that is to get an idea of what your current situation is. So that includes the family, the assets you hold, any liabilities, and actually how you hold the assets, the various entities that you might have involved in your estate. Then we try and identify what your key objectives are. And we're going to go through that in some detail. There's sort of the obvious objectives, and then there's some underlying objectives there that we can tease out. The third step we do is try and provide an external sort of check and balance and maybe ask some difficult questions to see whether those objectives are all achievable. Often people have a long list of objectives, but when you actually align that with your current situation, it may be that you need to prioritise some objectives over others. Once we've got that all set up, we then document the succession plan. So that's using a number of strategies and documents to put the plan into place. And then we implement the plan. And really, when we talk about implementing a succession plan, it's not just the event of death and your will coming into play. It really starts with the process of getting your succession plan in order, which can really starting today, flows through up to the point of death, and then often quite some time after death. So really, it's a long-term, potentially process. And then we encourage you to revise the plan on a consistent basis. And the triggers for revising a plan, some people talk about it being a 3 to 5 year thing that you should look at it, but we sort of say that that's a good sort of benchmark, but really you need to revise the plan as and when things change. So if there's a major event in your life or with your family or with your business, then that's often a great time to look at the plan again and make sure that it's still going to work for you. So some basic questions you need to ask yourself as part of that process. What have I got? So what assets have you got? What liabilities are there? In this case, in the case study, we've got some on-farm assets or some very farm-related assets, and we've also got some off-farm assets. You need to ask yourself, how do you hold them? We often find that when people come to us for their succession planning, that they understand what assets they've got, but they're not entirely sure in which entities they hold them, because over time they set up trusts, they set up super funds, they go into partnerships, they hold assets jointly. So it's really important to understand how you hold those various assets. Then the question is, who's going to get those assets? So a simple plan is that you just divide all your assets equally between your beneficiaries. But in the context of farm succession, it's usually a little bit more complicated than that. You need to identify who's going to get what assets and in what proportions. And then perhaps one of the most important questions in the context of succession planning, which, as we've said, is this long-term process, is when are they going to get their assets? And quite often it's not just on your death. It's usually some sort of arrangements put in place prior to your death, and then quite often there's other arrangements that apply after your death. And then how are you going to give your assets to the next generation? We're going to go into some details about various options that you've got as to how that happens, whether it's through trust or whether it's outright gifts, whether they're transferred during your lifetime or whether it happens on or after your death. But if we also need to just think a little bit more deeply about some of the issues that are often overlooked in the context of succession planning. If you've got kids who are under 18, then a really key question for that generation is who will look after your kids. That can also apply for older kids in the sense if you're already, or if you're involved in the farming operation at the moment and your kids might be over 18 and be involved in the farm, but there might be elements of the operations that only you understand or know about that you haven't had the chance to pass on to your kids yet. And then, will your kids end up with anything in the context of our case study? Will Jesse, for example, end up with anything if the off-farm assets need to be used to fund your retirement? Will they keep what they receive? There's a lot of options or a lot of things that can happen to the next generation that might mean that the assets you pass to them aren't ultimately kept by them. And will they be able to make wise decisions, particularly if you're not there? It's one thing to be there where you can guide them and mentor them during that time when they're taking over the farm, but we need to plan as if, unfortunately, you're both hit by a bus tomorrow, and how are they going to be able to be mentored into making wise decisions if you're not there? And will unfairness lead to family disputes? It may be that one child gets more of the total family pool than the other children, particularly if, say in this example, with Tom taking the farm being a lot more valuable than the off-farm assets. Is that going to lead to disputes? And are there ways to put things in place that will minimise the chances of those disputes arising? And then how much will the taxman get? There is opportunities throughout this whole planning process to minimise the impact of tax on your estate and provide and set your children up with an arrangement that means that they're ultimately going to pay less tax in the future than they might otherwise do. But we can go even another layer deeper and ask some sort of more fundamental questions like, is the farm viable? So, we often have people come in and they want to enter into a succession plan to pass their farm on, but it may be that they're passing it on to more than one child. In our case study, Ben might potentially want to come back and work on the farm as well. And at that point, Liz and Jeremy would have to assess whether or not it's viable for those two children to take over the farm. But perhaps more fundamentally, is it viable for Liz and Jeremy to be earning income on the farm and Tom? So, can the farm support two families at the same time? Are future generations really interested in farming? Often there's the assumption that a child who's currently working on the farm is actually interested and will be interested for the long haul. That may not be the case, and sometimes that question hasn't even been asked. Can both Tom and Ben farm? We've already touched on that. So, if it's the case that Tom's currently on the farm and as Ben gets a bit older, he wants to come back on the farm, is that going to be possible? Or do they need to start managing those expectations now? And is there enough for, as we've talked about, Liz and Jeremy in this case, retiring and facilitating the kids coming back on the farm? Another concept or desire we hear quite often is keeping the assets in the bloodline. So this is the concept that as Liz and Jeremy's generation passes it to the next generation, they want to ensure that there's strategies in place to make sure that those assets don't end up with, say, for example, a former partner of one of their children, or even at Liz and Jeremy's level, whether or not it can end up outside the bloodline at that level. And also, what are the unspoken expectations? We'll touch on that shortly, but it's important to, as part of this process, is to encourage everybody to speak openly and to get their expectations on the table so that they can be managed and disputes can be avoided. So we need to really think differently to address some of these deeper considerations. So part of our role is to provide an independent and frank view about what can be achieved, the lining up of the sort of expectations and the reality of the situation. One of the things that I think is everybody has to think about on a periodic basis is the opportunity cost of maintaining the farm. So farm's often a very valuable asset, and land is increasing in value. significantly, and has done over the recent times. And the return from, say, $4.5 million worth of land is relatively small compared to the lifestyle that money could buy in a different context, say if the family sold up and moved to the city. The other thing is the on-farm and off-farm assets. How can they be used? For example, in our case study, the restaurant might provide somewhere where Liz and Jeremy could retire and actually make a go of earning some income and providing for the farm to then be able to comfortably support Tom and potentially Ben as well. So really, it's this stay or sell question, and it's often assumed that the family will stay on the land, but I don't think that we should necessarily start from that conclusion. Some alternatives that people could consider is obviously selling the farm and doing something else. We've talked about that. Even selling the farm and realising the money, and then if people are interested in farming, there's always the option of leasing land, or you could even do a combination of those. So keeping some land and then leasing other land to make a bigger farm viable. And there's also just the opportunity to move off the land completely, maintain it as an asset, and then lease it to somebody who wants to put that with a bigger land holding. So when we talk about what assets you've got, there's really, most people are familiar with the assets that they own in their own names. So personal chattels, things like furniture and houses, bank accounts, maybe even sort of some shares. So these are things that are owned personally and you can deal with through your will. But as life's got more complicated over the years, there's actually often sort of quite a small amount of assets that are owned personally by people. Usually they might be owned by a spouse. So sometimes people put assets in a spouse's name so that they are effectively a person of straw. So something happens to them in their business or as a director, they don't have any assets in their name, so they're holding them in a spouse's name. And if you can't deal with your spouse's assets through your will, only your spouse can deal with those. The other type of assets are jointly held assets, and these will pass to the other owner. So if you own a house, for example, the townhouse in this example, if it's owned between two people, then that house will pass immediately to the joint owner. It won't pass through your will. Then there's superannuation. So superannuation isn't an asset that's necessarily goes to your estate. It'll be sent by the trustee either in accordance with what the trustee thinks is fair, or in accordance with a binding nomination that you might leave. Then there's life insurance. Sometimes people have life insurance to provide sort of for key man risk or to pay off debt if something happens to them. Life insurance is a contract, and you can actually specify in that contract who will receive that payment if the event happens, if your death happens. That's something you need to plan for. Informal loans and gifts are another category of notional asset that can cause problems. So often people will advance money to a child so that they can do something, either buy a bit of land or buy a house or something like that, but it's not made perfectly clear at that time whether or not it's a loan or a gift. And then when you pass away, there can be an argument about whether or not that person has to repay your estate or whether or not it was an outright gift. So you can avoid that by making that clear. And then finally, we have family trusts or farm trusts, where these trusts are often discretionary in nature. And what that means is that nobody has a fixed interest in them. And it's important that particular strategies are put in place to pass control of those assets in the way you intend, rather than them being sort of left hanging out on the side. So these various structures and assets on the right-hand side are what we call controlled assets. And it's really the combination of the personally owned assets and the controlled assets that constitutes your entire total wealth that you need to deal with as part of your succession planning. So going back to our case study, we've got Jeremy and Liz. We can have a look at how they are holding the various assets that we've identified. So first of all, we've got some land that Jeremy has inherited through his parents' will. So that's in his name personally. Then we have some farming land that Liz and Jeremy have purchased during their own generation, and that's been purchased directly into the Jones Family Trust. And we have some farming equipment, which is held in a partnership between Jeremy and Liz. And then we have the commercial property and the restaurant that's run out of that commercial property in the Jones Family Trust as well. Jeremy is holding the beach shack in his own personal name, and Liz is holding the townhouse. And this is probably done for land tax purposes to keep separate ownerships. And finally, we have the shares and cash in the self-managed super fund. So as you can see there, there's actually quite a complex or sophisticated ownership structure for the various family assets, and we need to deal with all of those entities and all of those ownership arrangements in both of Liz and Jeremy's succession planning. So we now have an understanding of the high-level objectives of Liz and Jeremy. We've identified some deeper issues that they need to think about, and we know what assets they have, and we know how they're held. So I will now pass across to Kasha.
Okay, thank you, Andrew. So I'm going to talk a little bit more about Jeremy and Liz's scenario and particularly explore what it might look like for them to distribute their worldly assets. So we'll start by talking about the two standards that might apply in an estate planning scenario. So we've got what's on the screen is called the city standard. So that's the sort of scenario that we'll often see for people living in the city. They're not rural families. They don't have the same sort of concerns as rural families. Really, their concern is just passing on all of their assets to the surviving spouse and then to their children equally. So pretty straightforward, not much to sort of consider in terms of often not everyone has a trust or a farm or commercial property to take into account. So there are some things for people that are applying the city standard to think about, but it's really clear that the country standard, or what people that might be engaged in farming or running a rural business have to think about, is actually a lot more different to the city standard. So often for the people that need to consider the country standard, often their considerations are, well, we want to keep the farm viable. We want to make sure that the surviving spouse is able to maintain their lifestyle and have a nice, healthy retirement. And they also want to provide a fair inheritance to their children. So a little bit similar to the city standard, but often the main thing that makes the difference is that with the country standard, as you can imagine, the farm is the biggest asset. There's generations and generations of work that's been put into the farm. It's the most valuable asset in the family, and often there's only one or maybe two children at the most out of a group of children or further children that are really interested in taking that on. And unfortunately, the case is that you can't run a farm without the land, and that is something that the country standard, or people that apply the country standard, are very much alive to. So in terms of the country standard, what we've often seen is that what is fair is not necessarily equal. So in the context of Jeremy and Liz, there might be some expectations floating around the family group. Some might be spoken and some might be unspoken. So these are some of the things that might be running through people's minds. Perhaps for Tom, he might be thinking, I'm entitled. He might be thinking, I've worked on the farm before school, after school, got up early and went to bed late. Perhaps he's sacrificed his own personal time and not gone to do things like traveling or going interstate, that sort of thing. He's really dedicated his life to the farm, and perhaps he's thinking, I'm entitled. Another thing that might be crossing his mind is, I've earned it. I've worked really hard. I've supported mum and dad through running the farm, or my dad and my stepmom, and I think that I've really earned my place and I should be the one that receives the farm. Perhaps from Jeremy's perspective, he might be thinking, well, I'm happy to leave the farm to Tom, but I don't want him to sell it. I want him to continue running the farm. I want Tom's son to run the farm. I want his son to run the farm. I want all of the next generation to have a go at running the family farm. It's been running for generations and I'd like to see that continue. So I'm going to try and set it up in a way that perhaps Tom can't sell the farm, or perhaps there's something restricting him from doing that. Sometimes there's also a lack of expectations. So perhaps Jessie or even Ben is sitting there thinking, well, I don't really want anything. I'm not really interested in farming. I'm pretty happy with my life here in Adelaide. My husband and I have earned enough. We're pretty comfortable. So perhaps we don't actually need anything from Jeremy and Liz. Jessie might also be thinking, well, obviously Tom's going to get the farm. He's the one on the land. So perhaps I just have to look at providing for myself. Perhaps my husband and I have to go off and make our own way. And perhaps Ben comes to that realization too. Or there might be the expectation that, well, actually all the off-farm assets will end up with me. So the super, the townhouse in Adelaide, maybe the beach shack, all of those assets will end up with me. And that seems fair because obviously my brother Tom's going to receive the whole of the farm. So as you can see, there are a few different expectations that might be crossing people's minds. Whether or not they're communicated can make the difference between a harmonious estate plan and perhaps something that's not quite as harmonious. So these are just some examples of what we might be having to consider as we go through the process for the Jones family. And we need to just think about matching those objectives with expectations. So this is what it looks like if we were to apply the country standard to the Jones family, and Tom was to receive all of the farm assets, and Jessie and Ben were to receive what was left over. So these are just some nominal values that we've attached to those assets. As you can see, if Tom ends up with the $4.5 million asset, which is the farm assets, then he ends up with a rather large 68% split of the family wealth, leaving with Jessie and Ben with just over $1 million in assets each, splitting them each out at 16%. So like we said before, what is fair is not necessarily equal. So I'll pass back to Andrew, and he's going to talk about some of the strategies that you might like to consider if this is relevant to you.
Thank you. All right, so if we talk about if strategies is to pass the farm on to Tom, a key question is whether or not that's going to start to happen now, or whether that's going to happen on the death of Jeremy, or even on the death of both Jeremy and Liz. So from Tom's perspective, this can be quite an important issue because he's getting on and he's got his own family, and he wants to know that he's got the security of the farm, and that he's not potentially going to have to be dealing with, he's not going to be building up value in the farm and then having to be dealing with his siblings or his stepmom down the track after he's created even more value and worked really hard on the property. So one option that Liz and Jeremy have is to provide the farm to Tom now, and in this context, Tom would get the upside and have the security of the land. So that's obviously something that's going to be important to Tom. From the parents' perspective, moving the asset now rather than on their death might trigger stamp duty and CGT that wouldn't otherwise apply, and that needs to be managed quite carefully. The good news is that there are quite a lot of concessions, both from stamp duty and CGT, that can mean that it is possible to pass these assets on prior to death, but you need to make sure that you qualify for those. The other thing is that passing them on now might actually have some tax benefits as far as stepping up the cost base or the tax value of those assets and setting Tom up for some tax savings down the track. A key question which we're going to touch on the next slide is whether or not the current generation gives or sells the land to Tom now. And if they give it, then obviously that's going to reduce their asset base. And if they sell it, then they're basically swapping the farm asset for another asset in the form of potentially a loan that they've made to Tom to facilitate his purchase of the farm. The other thing that the parents will want to do is manage external debt. So as Dimitri said, there's $1 million of debt against the farm at this point in time, which is Liz and Jeremy's responsibility. If they're going to pass the farm to Tom now, they'll want to make sure that Tom takes over responsibility for that $1 million. They don't want to be left with the debt and giving Tom the upside of the land. So that needs to be taken into account. And the other thing that the parents might be concerned about is keeping it in the bloodline, because if Tom takes the farm now, then the farm is an asset that becomes exposed to all the risks at Tom's generation, which could be him potentially splitting up with his partner, or making some bad business decisions, or even things like driving an unregistered car after a couple of beers, dog biting somebody, cattle getting out. There's a lot of things that could potentially give rise to liabilities that may impact that asset. Another benefit which Tom might wish to get is the fact that if he takes the farm now, then be challenged later on. Whereas if the assets are passed on death, then they can be challenged under the rules that enable certain people to challenge a will. On the other hand, if Liz and Jeremy pass the farm to Tom on their death, then there won't be any stamp duty. That's just a blanket exemption for assets passing on death. There won't be any CGT because there's also a blanket exemption for that. The downside being there that Tom would then take the land. There'll be no CGT for the parents, but Tom would then take over the land with the same cost base as the parents. So whatever the parents paid for, that's what Tom would have as his cost base, and he'd have to pay tax on any value that he realised over and above that, which could be quite significant. So he's really taking the assets subject to an inherent tax liability. A benefit, or a potential benefit, is that the parents could leave the land in a testamentary trust for Tom, and that could be used to provide some more protection for that land as far as keeping it in the bloodline. And there might be also some tax benefits to Tom and his generation from receiving those assets in a testamentary trust. But if, as we've said, that Tom receives, say, $4.5 million worth of assets on his parents' death, and his other siblings receive $1 million each, they may not think that's fair, and they might bring an inheritance claim if they haven't been adequately provided for. So it can be challenged. So let's assume that Liz and Jeremy say, no, look, we're actually going to pass the farm to Tom now, as opposed to our deaths, because we want to give Tom the security of having the land in his name, and giving him the upside. So there's really two ways that the parents can do that. They can either give some or all of the farm to Tom, or they can sell some or all of the farm to Tom. So we'll go through what the outcomes are if they take either of these options. So if they give it to Tom, it's really an early access to his inheritance. It's like receiving his inheritance, before their death. One of the benefits potentially for the parents is that their personal estates are then reduced by the value they're given to Tom during their lifetime, and they might qualify for things like the old age pension, or a medical card or something like that. That might be something that's important to them, but really in the context of somebody or a family with $6.5 million worth of assets, it may be perhaps a bit of a furphy issue that they're focusing on and perhaps shouldn't be focusing on. There may be significant changes in the family wealth between when they give Tom his early inheritance and when they ultimately die. So, for example, the off-farm assets that they're notionally keeping for the other siblings, they might get all used up during Liz and Jeremy's retirement. So there might not be much left over for the other siblings. On the other hand, Tom could make some bad decisions, and the value of the farm could go down significantly, or he could lose it completely, in which case he might be able to come back and have another crack at the off-farm assets and effectively get his inheritance twice, which wouldn't be fair to the siblings. And as we mentioned on the previous slide, if Tom is given the asset, then it becomes a big, valuable asset with equity in his name, and it makes Tom a target for potentially, if he splits up with his partner or creditors, he makes some bad decisions and creditors come knocking. He would also have to deal with the $1 million of debt. So in the context of gifting the farm, they would have to somehow transfer that debt to Tom. It would be possible, but it might not necessarily be a neat way of doing it. What might actually work better in this context is to sell the farm to Tom, in which case Tom would borrow perhaps $1 million from the bank to repay his parents, so that the parents can then repay the $1 million they owe to the bank. So that's got rid of the bank issue for the parents, which is a good thing. And it's really pushed that $1 million worth of bank debt down to Tom's generation, which is where it would belong if that's where the land was as well. And then the balance of the value that is the farm that's being sold to Tom would be potentially loaned from the parents to Tom. So in this case, Tom would have a $4.5 million loan back to his parents. So what this would do would mean that Tom has got the property in his name and is really then taking real risks, but he also gets the upside associated with the farm. So if the farm is currently worth, say, $5.5 million with the $1 million of bank debt on it, and the value of the farm goes up over the next 10 years, then all of that value goes to Tom and stays to Tom, and it wouldn't be something that his siblings could make a claim against that extra value. Another benefit in doing it this way is the equity in the farm, so the $4.5 million that the parents have effectively moved to Tom, would be covered by the amount owed back to the parents. So if you looked at Tom's balance sheet, there'd be the land, and then there'd be the bank debt, and then the parents' debt, which would mean that if somebody made a claim against Tom, whether it be a former partner or a creditor, there wouldn't be a lot there for him to, or for that person to claim against. So that really protects that equity over the period of time where things might not go so well in Tom's life as is, at a younger time. And Tom could use the profits from the farm to repay debt, potentially pay capital amounts, and that would then go back to the parents after the bank had been paid and provide the parents with an income stream and the ability to get access to additional capital in retirement if they needed it. So rather than being in a position where they've given it to Tom and then they are really on a fixed income and a low amount of wealth to fund their retirement, by keeping that loan in place, it really gives the parents some options to deal with things that they might not anticipate in their future. There is an issue in the sense that the parents have retained an asset, being this $4.5 million loan to Tom, and they need to deal with that either before they die. They could forgive some of that loan to Tom. They could even give some of that loan to the other siblings, in which case Tom would then have to pay some money to his siblings over time to even things up. But if it was left through the parents' will, then if it wasn't left equally, in the sense that if it was all given back to Tom or it was given mostly to Tom and a little bit to the siblings, then there is still that potential for the siblings to make a challenge. But I think overall that the option of selling to Tom rather than giving it to him early provides a lot more flexibility and benefits for both Tom's level and the parents' level to really bridge that gap between when the parents are moving off the farm and Tom's really taking control and starting to make decisions for himself. And it may be that you consider a mix of both, so selling it and then forgiving some of the loan over time, but both strategies can form part of your succession plan. As we talked about, if you're either giving or selling the farm to Tom during your lifetime, then you need to consider the CGT aspects, the stamp duty aspects, but as I've stated, there's pretty generous concessions for both CGT and stamp duty that should mean that that can be done, provided it's planned for appropriately. And I will now pass to Kasia.
Thank you. So now that we've covered some of those strategies, we're going to have a little bit of a think about how we can structure Jeremy and Liz's estate planning, and in particular, how the assets that they're passing on to the next generation will actually be passing. So in this part of the discussion, we'll cover the topics that are on the screen. So wills, outright gifting, gift over, and testamentary trusts. Just a little recap on wills for people that aren't familiar. A will is a document that sets out all of your intentions for your assets and liabilities after you've died. So it only comes into effect when somebody dies, and the people that are appointed in a will to deal with those assets and liabilities as intended and then pass on assets to their intended recipients is the executor. Once the executor's called in all the debts and paid them out and there's a net sort of asset pool left, then they're in a position to pass those assets out to the people that are meant to receive them. And those people are called the beneficiaries. So I think it might be useful if we run through some visual scenarios that show what it looks like if we apply the two gifting options that are on the screen. So the outright gift, the testamentary trusts, and then applying what's called a gift over as well. So if we look at what's called a simple outright gift, as you can see, we're using Jeremy as the example here. So Jeremy's got the farming assets, for example, some of those are in his personal name, and he'd like to leave them to Liz. So if Jeremy doesn't want to sort of make too much of a complicated structure in his will, perhaps he just wants it all to be really quite straightforward when he's leaving assets to Liz, he might leave those assets to her in a structure that's called outright. So how that looks is Jeremy says, okay, Liz, here is the farm assets. I'm giving those to you through my will. No bells and whistles. They're yours to take. You can deal with them as you wish. You can control those assets. You can sell them on. You can encumber them. You can really do whatever you like with them. What that means is that the gift that Jeremy's left to Liz is relatively unprotected. So it's pretty straightforward to leave things, the assets to Liz, and lots of people like to choose this option in their estate planning when they want a simple sort of structure. But the risk is that if Jeremy leaves those assets to Liz, and she receives them in her name outright without any additional level of protection, and there's a claim against Liz, then those assets are lost potentially to the person that makes a claim against her. So the same sort of risks apply. She might hit somebody in her car, the cattle might get out, perhaps she doesn't make too good of a business decision one day and creditors are suddenly knocking on the door. This could leave the family farm up to the hands of creditors who might quite have made quite a valid claim against Liz. So there's really limited protection in this scenario. If we contrast that scenario with what it looks like if Jeremy applies what's called a testamentary trust, so we'll consider this scenario using the same assets, so the farm asset. In this scenario, Jeremy's still leaving everything that he has in his personal name to Liz, but he's doing so through what's called a testamentary trust. So the testamentary trust, you can think of it like a protective bubble wrap structure, which will hold the assets for the intended beneficiary. It's set up through the will and it is like a discretionary trust, but comes with a bit of special treatment so that any assets that are gifted through the will go through into that testamentary trust and then they're protected for Liz's benefit. So Liz still has access to the assets in the testamentary trust. She can still utilise the farm, deal with it as she needs to, but it's in a protective structure. That means that she's protected if there are any claims against her. So same scenario again, Liz hits someone in her car, the cows get out on the road. Liz can say, sorry, creditor, those assets that you're trying to claim against aren't actually in my name. They're held on a trust that I benefit from, but go your best. You're not going to get your hands on them. If we think about what it might look like in a scenario where perhaps Jeremy's died, Liz has received the assets from his estate outright, and she meets somebody new. So Liz repartners, and her new partner comes with 2 children from his own marriage. So now we've got Tom, Jesse, who are Jeremy's children from his first relationship, Ben, who was Jeremy and Liz's son, and then her new partner who's got his own children as well. What this might become is that Liz perhaps stays in this relationship for the long term, and she and her new partner head off to the solicitor and they decide to do some new estate planning documents. Liz could quite validly, because there's nothing stopping her at this point, because she's got the assets from Jeremy just directly in her own name, they really are hers, she can do what she wants with them. So Liz might pass away, and when she's passed away, she's prepared a new will prior to her death, and that leaves everything to her new partner. So ostensibly, her partner ends up with the farm. And what does it look like when her partner passes away? Well, the farm ends up with his family. This leaves a big question mark over Tom, Jesse, and Ben's entitlement. Perhaps Ben has a claim because he is Liz's biological child, but Tom and Jesse at this point could quite validly miss out from benefiting from the farm. If we consider what it would look like if we use testamentary trusts in that scenario, Jeremy leaves all of the farm assets to Liz. They pass over to her in a testamentary trust. She enjoys the benefit of the testamentary trust and gets to maintain the farm and keep running the business as intended. She still repartners, and perhaps she stays in that relationship for the longer term. She passes away, and what happens next? How does her will apply? So in this scenario, Jeremy's done potentially what's considered the more protective way of gifting, the testamentary trust. And he said in his will, well, I'm setting up this testamentary trust for Liz, and there's what's called a gift over provision in the will. So that says that if Liz can't benefit from the assets left to her in the testamentary trust, then the testamentary trust is going to be held for the benefit of my biological children, which includes Tom, Jesse, and Ben, and that effectively quarantines the farm assets that Jeremy's left to Liz from Liz's new partner and then his biological children too. So the benefit here is that we maintain that bloodline structure. So Tom, Jesse, and Ben still get the benefit of the farm. It continues to be protected, and the new family that Liz might have entered into, they don't really get any say in that. So if we have a think about what were to happen if Liz were to pass on and she leaves assets that Jeremy's left to her to the children, we have Tom, Jesse, and Ben on the screen, and they're each receiving something. If something goes wrong for Tom, so say he receives the farm and business goes well for a while, but he makes a few bad decisions and suddenly there are creditors knocking on the door, or potentially he's unable to service a debt that's been left behind, those creditors, the bank, anybody else is able to quite validly claim against the farm assets from Tom. Considering Jessie's scenario, perhaps she splits up with her husband, John. Everything that she's been left from Liz and Jeremy, unfortunately, has to go into the pool of separation, or the pool of family assets that can be divided up between Jessie and John, because those assets are held in Jessie's name. They're not protected, and so John could quite validly walk away with a chunk of the farm and leave those assets to perhaps a new family that he has with somebody else. And Ben, young Ben, he's in Adelaide. He's having the time of his life, but he's not really very mature yet. So perhaps Ben is influenced by the people around him. He's not too good with money. He has expensive taste. And so leaving assets unencumbered or sort of unprotected to Ben could mean that he ends up with not much left at the end of the day. And perhaps he could end up blowing it all before the time that he's reached the age of 30 or 35. And therefore he's left without any inheritance at all. So if we apply testamentary trusts in these scenarios, if we give Tom a testamentary trust with the farm, then the assets that have been left to him are protected. And if any creditors come knocking at the farm gate, then he can get them to leave him alone pretty easily by telling them that he's got a testamentary trust and the assets that he holds in his own name are pretty minimal, so they can go and have a go at those if they want, but the farm is tucked away and protected in that protected structure. Same with Jessie. So if Jessie and John have a breakup and there is a division of assets to be completed, Jessie can say, well, I've only got the assets that we have together, you know what I've got, and any other assets that I've got are held in a trust for my benefit, so they are protected. John has a more difficult time claiming against her in this scenario. And finally, Ben. Well, we're going to protect Ben from himself. Perhaps Jeremy and Liz have thought about this and they think perhaps Ben needs a little bit of help in controlling the release of the funds and the control of the funds that have been left to him. So Catherine will touch a little bit more on that moving on, but in this scenario, we've got Ben receiving his inheritance in a controlled and responsible way. So the outcomes of all of these things are that we've given the assets to all of the children, and we've had to think about how we can reduce stamp duty on dividing up the assets. And we've also considered protected gifting structures so that the assets are protected against any kind of claim that the beneficiary might experience personally. Now, there are a couple more things to think about, and we touch back on that total wealth concept that Andrew spoke about. Liz and Jeremy need to have a think about how much super they have, who will receive their superannuation, and how they're going to pass that superannuation on. So they need to have a think about putting in place some documents that give directions to the trustee of their super fund to make sure that super ends up exactly where they intend. In the absence of having those documents in place, then they will have some difficulty potentially if the surviving spouse ends up with control of the super fund and has repartnered. So Jeremy and Liz should really consider those aspects, and they should keep in mind that super does not automatically form part of their estate, so they need to deal with it quite deliberately. And for the family trusts and any other sort of entities that they've had set up, they could consider putting in place a family charter, which is like a rule book for how those entities are to be controlled and managed, and make sure that those entities are dealt with and pass on to the next generation in a controlled and deliberate way. So the last few documents that I will touch on before we hand over to Catherine are what's called often the living documents, or your living will. So the top two documents, enduring powers of attorney and advance care directives, really important to keep in mind that these documents should be done at the same time as your wills. So for Jeremy and Liz, we'd be recommending that they do those two documents. Those documents appoint somebody to act on Jeremy and Liz's behalf for medical decision-making, health and lifestyle in the case of the advanced care directives, and legal and financial decision-making in the case of the enduring powers of attorney. So those documents will appoint someone to take those steps and manage their personal affairs in the event that they're still living, but they've not got what's called capacity, so the ability to make those decisions themselves. So really important documents, very powerful, and they should have a think about who they appoint. In the absence of having those appointments, it means that things like as simple as calling up Telstra or dealing with the bank, all the way up to dealing with land or dealing with banks or selling assets off, could be restricted for the next generation, and it could make things very tricky. The other thing that they should consider are company powers of attorney for any companies of which they might be sole directors, so that if something happens to the director, the company can validly keep operating in that director's absence whilst the director is incapacitated or if they've died. So they should really consider that, especially if they're running a business through a company. And the final thing to think about for the trusts are changes of trustee and appointor. So those are controlling roles in the trust, and they should consider, Jeremy and Liz should consider who they'd like to take over those controlling structures and how they'd like to pass that control, whether it's upon death or on some kind of other event. So as you can see, we've now dealt with all of the total wealth, so super companies and trusts, and Jeremy and Liz have received some advice about how to handle those entities. And we've also provided for the time before death, which is where often we see lots of people get a little bit stuck because maybe they haven't thought about it. So Jeremy and Liz, well done. They've covered everything off. And I'll now hand over to Catherine, who will talk to us about the next generation.
So you may be sitting there thinking that the situation that we've discussed with Liz and Jeremy doesn't really apply to you. You might be at the Tom and Anna stage where you have young children and you haven't really had a chance to consider who will take over the farm. If your children are only 5, they probably haven't made that sort of life decision just yet. Or you, on the flip side, you might be at the same stage as Liz and Jeremy, and you might be thinking, I don't want to put all this time and energy and money into setting up an estate plan for myself for Tom to waste it if something happens to him and he dies young. So you might be wanting him to start thinking about his own estate planning at the same time you're thinking about yours, and getting his succession as best as he can, given that there's so many unknowns in his situation. So to recap on Tom and Anna, they're still quite a young couple. They have a young son, Alex, who's only 5. They might be considering having more children, but they have farm equipment in their own names, farmland, and some debt as well. And they might also be, Tom might be about to receive that gift from his parents or purchasing further farmland from his parents. So their objectives are similar to Liz and Jeremy's, but they have the added complexity of having to provide for young children. So they want to provide for each other. They want to be able to continue to service the debt. They want to be able to continue living on the farm. And if that isn't enough, they also need to consider caring for their children when that surviving spouse obviously doesn't have much time to do all of those things at once. They also want to leave something for their children, some inheritance for them, and keep the farm in the family if they can. So their assets are held in a pretty simple structure. So the farm equipment is held in a company. The company is also acting as the trustee of their family trust, and they have some debt in their personal names. So the key issues for them is providing for the surviving spouse. They don't want to be in a position where the spouse doesn't have enough time to grieve. It's really important to think about when you're planning your succession that you don't want to die one day and your spouse to be panicking the next because there's no money coming in, and what do they do? They need to think about how they're going to service and repay debt. So that's the debt to the ANZ Bank, as well as the debt to potentially mum and dad, and ensuring that there's income in the farm so that they can continue to make those payments. They're probably also quite conscious about blowing up the kids. If Tom and Anna both die young, they might be thinking, don't want to leave big inheritance to my 18-year-old who might not be able to manage that effectively. If Tom and Anna both die young, they need to think about who's going to look after their children, both in terms of who's looking after their money, as well as who's in charge of the day-to-day looking after the children. And if one of them is to die young, the other spouse might repartner and might be in a new relationship, and they need to consider how to manage that. Ultimately, Tom and Anna want each other to be happy, and no one's judging anyone for repartnering, but it is something that you need to think about if you want to make sure that the assets that Liz and Jeremy have firstly built up for Tom stay within that bloodline. So, like with Liz and Jeremy, a testamentary trust is a really useful strategy to implement in their wills so that they can choose who gets what under their will to make sure that the assets stay in the family line and ultimately end up with their children. It's also an excellent protection for protecting the assets that are in the testamentary trust. So as Kasia discussed, repartnering at-risk beneficiaries, but at this stage we often also consider second chance trusts, which we'll discuss a little bit more later. In terms of an additional benefit for the testamentary trust is that there's particular tax benefits that come with testamentary trusts so that children can receive a higher income from a testamentary trust than they can from a usual discretionary trust, which means the income can be split among a wider range of beneficiaries so that hopefully no one's paying the top tax rate, or if someone does have to pay the top tax rate on income, it could be spread among a number of people. So as we discussed, no one wants Tom or Anna to be lonely. If they want to repartner, they can. But it's important to give some consideration to what happens if the worst happens tomorrow. You know, you can't plan when bad things happen, but you want to be able to set things up so that if the worst does happen in a relatively short time, there's something in place to protect your wealth for the children. So the first thing is a deed of mutual wills. This is a contract between Tom and Anna where they essentially agree that the terms of their wills will continue to apply until they agree otherwise. So if Tom dies first, Anna would be bound to keep the current terms of her will in place. She would be allowed to spend money in accordance with how she did before Tom died, but she can't go wild and sell everything and take all her friends to Bali for a big party. The second option is a farmland trust. So, excuse me, Tom may consider transferring some land to a trust so that it's held in a protected structure, and he might put some directions into that trust about who takes over on certain events. And there might be clauses in the trust around who the beneficiaries of the trust are. So it's only relatives of Tom and his family who can benefit, so that if Anna later repartners, her new spouse and his children can't benefit under the terms of the trust. With a testamentary trust established in the will, you might have an independent person sitting alongside the beneficiary of the trust so that they have they sit side by side with the beneficiary as a trustee, and they have to make decisions jointly with the beneficiary so that the beneficiary can't just take everything out of the trust and spend it at once. The final strategy that is often discussed both when Liz and Jeremy pass the farm to Tom, and it might be a condition of passing the farm to Tom, as well as something to think about in Tom and Anna's own estate planning, which is a prenuptial agreement, or as we call it in Australia, a binding financial agreement. It's a bit misleading to call it a prenuptial agreement because you can make a binding financial agreement at any stage of a relationship. So it can be before you marry, during a marriage, or even when you separate to divide your assets. The benefit of this is that you can pre-decide how you're going to split the assets should Tom and Anna separate. So if things get nasty and bitter between them, there's less complication and they can walk away at the end of the day knowing what they're going to get. Obviously, these BFAs are controversial documents and they're not for everyone, but we find that if you approach it in the right way and you have open conversations about why you're entering into the agreement and the purpose, which is to keep the farm in the bloodline, it can be a positive conversation around what everyone's ultimate goals are. So the second chance trust, which we discussed for the gifts that Tom and Anna leave to their children. So importantly, the assets of the trust are available from the date that Tom and Anna die for the support, education and advancement in life of their children. It's available from day one. So if Tom and Anna die, the trustees of Alex's trust can take assets from the trust or income from the trust and use it to provide for his education and general advancement. So it might be providing for a private school education. It might be that there's some opportunity overseas that Alex would really benefit from, and the trustees of the trust can put aside some cash to do that, even though Alex doesn't have complete control over that trust yet. So it might be that Tom and Anna die while he is quite young, and then he turns 21. And at 21, you're probably not going to be able to have much of a conversation with a bank about buying your first home. But it might be that Alex is really mature, and he might say to the trustees of the trust, look, I'd really like to spend some of the money that mum and dad left me to put a deposit on a house and get myself set up for life. And the trustees of the trust have the option to loan or gift that money to Alex at that time. And if it's a loan, he might have to repay it back to the trust, which, although it's ultimately set up for his benefit, that's a way for him to learn about saving money and budgeting, as well as being able to, he's not taking assets out of the trust that he could potentially waste. Then on his 30th birthday, the terms of the trust might say that Alex is entitled to have control over 50% of the capital of the trust. So he can take that 50% out of the trust and he can do whatever he wants with it. He might decide to blow it all at once. If he's a very, mature 30-year-old, he might decide that he gives it to various friends and family for whatever reason. Or he might use it wisely and start up his own business and start making a name for himself in whatever industry he chooses. However, he might then find that the business he set up crashes and that business was held in his own name. And so the assets that he was given from the testamentary trust are now at risk of creditors. The problem with that is it's all at risk. The legacy set up for him by his mum and dad is potentially blown. But with the second chance trust, he's only actually had access to 50% of the capital of the trust. So although that's gone, then when he turns 35, he has another opportunity to access the capital in the trust. So he's able to have a second go at setting himself up and perhaps learning from some of the decisions he's made previously to be able to use the inheritance as best he can. The ages we've chosen here are all very arbitrary, and it's obviously a decision for people making their wills to make for themselves about probably looking a bit back on what they were like when they were younger and what ages they probably would have felt like these inheritance would have been useful to them, as well as when maybe they would have made some poor decisions. But to give that's just to give you a bit of an idea, and everything about that is quite flexible, but it's an important strategy to consider. The other thing to consider is who you appoint in some really important roles in your will. So the executors are the people who are in charge of managing sort of the day-to-day maintenance of your will after you die. So they call in the assets of your estate, they pay all your liabilities, and then they distribute those, the remaining assets to your beneficiaries. The trustees are the people who are appointed over the testamentary trust established in your will to make decisions on behalf of the benefit of the trust and to invest and to spend money on behalf of the trust. And the guardians are the people that are appointed to look after your children. So to start off with, it's a lot of work to be appointed in any of these roles. It's often time consuming. It can be a role that has a bit of conflict. You can have lots of questions as an executor about why you're doing things in a certain way, why you're taking so long, why won't you just give me money now, it's all fine, those sort of things. So it's important to put someone in that position who can deal with that sort of criticism, as well as understand the importance of the role they're doing. So often when people come to us, they say, I want to appoint my 3 kids, which is fine. That often works for people. But it doesn't work if your 3 children don't get along. If 2 are going to gang up on 1, it can be a nightmare to deal with, and you might even have to apply, your executors might need to apply to the court to resolve some conflict. The other option that some people have is to appoint a professional advisor, so their lawyer or their accountant, who can step in as a professional, understand your structure, and work it all out. The downside of appointing a professional advisor is that they're probably not the best person to deal with things like your jewellery, your personal effects, all the sentimental things that are in your house that have to be dealt with at some point. So a really good way to deal with this is to appoint a mix of both, so that there's someone to deal with the personal effects and perhaps potentially manage your funeral and those sorts of things, as well as a professional advisor who can support the family member who you've appointed as well. So the duties can be split between the people you appoint as your executors or trustees, and it can act as a checks and balances system so that there's always someone checking what the other person is doing, asking questions that the other person might not have thought of, and making sure everything's running as smoothly as possible. The other important thing to think about is what happens if the person you appoint in one of those roles isn't able to act. Lots of people like to appoint their parents or their siblings as the guardians for their children, but the reality is that those people could die before you. And so you want to have a backup plan for what happens if that person isn't able to act, so you don't have to update your will too often. So after thinking about all of those things, Tom and Anna have looked after each other first and foremost. They have a plan for what to do when the first of them dies, so that the other person has some time to grieve and then to get on with life and to think about their own future as well. We've looked after the children, so if the surviving spouse dies shortly after or at the same time, there's someone to look after the children, and there's those second chance trusts for the children to have some time to make a few mistakes like everyone does. There's also the protection of potentially the BFA and the deed of mutual wills, so that if there is a repartnering of the surviving spouse, the children are still going to receive an inheritance later down the track. And most importantly, we've preserved the family wealth for the children and hopefully their children and their children and their children. So we'll pass back to Dimitri just to summarise and conclude.
Okay, so a good way to think about your succession plan is to compare it back to something basic like a toolkit, for example. Now, in your toolkit, you'd have your estate plan, and your estate plan is what matches your objectives with your plan and ensures what you want in life is achieved during your lifetime and even after your lifetime. And you can compare your estate plan to your toolbox. You have your enduring powers of attorney and your advanced care directive. Now you can compare these to your Phillips head and your flathead screwdriver, very important tools. Powers of attorney to look after your someone to look after your financial decisions in your lifetime, and your advanced care directive to look after your medical decisions in your lifetime. Your life insurance and your income insurance, compare them to the nuts and bolts at the bottom of your toolbox. They're there when you need them, and they're quite handy. And probably one of the most important tools in your toolbox, which is comparative to your will, would be the cordless drill, for example, which would incorporate a testamentary trust, which could be compared to a backup battery to make sure that your cordless drill was working as efficiently and as really as you want it to. And now the same things apply to death benefit nominations, deeds of mutual wills, and everything else we've discussed in this presentation so far. So moving forward, you need to review what you have, think about what you want, and make a plan. But in doing so, you might need advice on potentially tax issues that might arise, on any potential transfers of land or assets between your family. You'd need advice on risk insurances. You'd need estate planning documents to be prepared to reflect what your objectives are and to basically put your thoughts onto paper. And you need someone to periodically review all of these instances. So we can project manage this all for you. So you need to ask yourself why overall, because things don't take care of themselves. And as I've stated in the beginning, you need to take some time out to put in place these strategies to make sure that the outcomes that you want in your life are achieved. So you need to ask yourself, why do you work so hard? Why have you worked all your life since you were young and saved up all your money and invested in potentially in properties and savings? Why do you insure what you've got? Why are you trying to protect what you have? likely because you want control of your assets, control of how they are now, control of how they're passed down to the future generations. Because of safety, you want to make sure that your assets are safe, your family's safe, and you want to protect your future and your family's future. So to go back to that first question that I brought up in one of our first slides, to think, how long has it been since you've taken any positive action to ensure that all of this is happening? You need to take action because your objectives aren't just going to happen. It involves a process, as we've discussed, and you need to think who will implement that plan. And Andrea of Lawyers can implement that plan for you.